I was injured from a medication. I went into kidney failure from a medication, and I did hire a firm to handle that case when they started the class action suit. It's been almost 5 years ago. They sent me a letter. I received it this week. It post-dated for May 5th, but the letter stated if I didn't contact them by April 28th, that I was going to be dismissed because I didn't have all the information. I called to find out why I was being dismissed because I had sent them the information 3 times. She checked the records and stated, well, yes, you do have everything. I don't know why they say you don't have it. So she told me she would call me back, and she did. When she called me back, she stated that they were going to dismiss my case because they can't prove that my kidney failure came from the product because I'm also diabetic, and that's one of the ailments that comes with diabetes. I was taken off of the medication when I went into kidney failure. Since I've been off the medication, my kidneys has gotten better. So I stated to her, well, if it was the diabetes, don't you think my kidney failure would have continued instead of getting better? So she said, well, we'll get back with you. And I want to know now, do I need to refile? Has the statute of limitations went out? I don't know what to do from here.
Okay.
Okay. So your case was probably placed in part of multi-district litigation, and what happens in that case is there are a number of cases that are like yours, similar to yours, from around the country that are placed within this particular court. This court could be not necessarily in Alabama, it could be in Philadelphia, it could be somewhere in California. But what happens is a number of these cases, this law firm is likely handling a number of these cases. And what happens is medical causation in many of these cases, especially drug cases, is proven generally through the medical records. So what probably happened was your attorney got the medical records and they're looking for certain things. And when I said they, yes, your attorneys, but also the court, the defense attorneys, the attorneys for the company. And they agree on certain criteria in order for you to qualify to be able to recover as a result of this particular drug. So what probably happened, I don't know, all I know is what you just told me, but what probably happened is they did get your medical records and you simply did not meet those boxes to check. That was as a result of your medical records that they obtained, so they couldn't prove what's called causation. And in order to have a case, you have to prove that the drug directly caused this particular injury. So I wouldn't necessarily put that on your lawyers. I'm sure that they did as good a job as they could for you. Not all cases pan out, and I've seen it time and time again. A lot of times they do, but a lot of times they don't. That's not to say that somebody didn't miss something on the court end, or the defense attorneys didn't miss something. But my guess is that your attorneys fought like heck for you, and the problem is that sometimes you don't meet that criteria. You can always check with somebody else, which I always recommend. Check with somebody else if you have a question. But that's probably what happened, and you probably won't be able to get in through another attorney group to prove causation because they're going to be looking at the exact same medical records. I hate to hear that, but there are a lot of times explanations for that.